I mean, the bulk of the policy, legal, and philosophical ramifications of, let's say, for example, the 1976 Copyright Act, I think are still apt and germane to today's music society. I think what happened was a lot of emerging technologies came about. When the emerging technologies came about, other uses and ways of exploiting, disseminating, listening to music came about that weren't envisioned before in 1976. I think that the basic underlying policies and foundations and principles of the copyright law are sound. I think that there's going to need to be specific addendums to the copyright law to address specific issues. Because what is becoming very clear now is that for entities or persons who wish to infringe, if it's not specifically spelled out and there's no specific recourse for a specific course of action that is really in contravention of the copyright law, that they will work that to the best of their ability, whoever an alleged infringer is. I don't think that copyright law is outdated or archaic. I think that what we really need to do is isolate problematic issues right now with regard to the dissemination of and infringement of intellectual property, and find ways to address them and to basically continually amend copyright law. I mean, laws get amended all the time. To amend copyright law isn't a big deal. It doesn't mean that we need to revamp the 1976 Act. The 1976 Act should be revamped at some point, hopefully sooner than it took from 1909 to 1978 for copyright law to actually be. 1976 Act was instituted in 78. That's a long time. That's 69 years. I mean, there were amendments, of course, along the way. Not to say that the 76 Act shouldn't be amended at some point, which of course it should, but I think it's principally sound. As far as specific instances, like copyright law doesn't mention Napster, doesn't mention iPods. I mean, those are commercial terms, obviously, but it needs to account for new uses. I think also we have a responsibility. I think artist managers do, the record company does, publishers do, artists do, record companies do, if I just mention them, to be aware that the last 10 years has taught us a lot about the way technology can change not only the world, but the music industry. To be aware of, now that we've seen how it's changed, to be really keen on tracking how intellectual property is digitally disseminated in the future so that we can prevent abrogations of copyright law with regard to digital infringement. But generally, I don't think that we're stretching copyright law that much. I really don't. I think that it's very adaptable, and I think that the principles that it stands on have been working in this country, I mean, for about 100 years. I mean, the 1909 Act there are a lot of principles inherent in that Act which are in the 76 Act. I think it's going to be a continual tightening up of the Act, but I think it's going to be here for a while, and I think we've got a great copyright. I think we've got a great body of copyright law and jurisprudence in this country. I really do.